for 15 minutes. Would you like to reserve any of that time?
Yes, Your Honor.
All right. You may proceed whenever you're ready.
May it please the court. This appeal concerns an order by a judicial referee that granted attorney's fees after Appellant National Merchants Association voluntarily dismissed her complaint, which was exclusively premised on the parties' contractual relationship and arising out of the parties' contracts. Now, thank you for the tentative opinion and the many questions posed. I hope to get to all of them within this short time. As to the first question, is this appeal governed by the abuse of discretion standard or the de novo standard of review? Specifically, did the referee make a determination of the legal basis to award attorney's fees, or did he only make a determination as to the entitlement and amount of attorney fees? I would submit that you can't bake a pie without flour. You can't make a decision as to an award of attorney's fees without...
Sorry, what is it you need for a pie?
You can't bake a pie without flour.
Without flour?
Yes.
No gluten-free pies?
There is gluten-free flour, Your Honor.
Ah.
They may try. We'll see. I don't believe you can currently bake a cake without flour, but I'll continue. The American rule, as applied in California, is that each party is to bear his or her own attorney's fees, except as provided by statute, law, or contract. And that is codified in Code of Civil Procedure, Section 1032. While it is true that the court's order or the referee's order here did not explicitly make a determination of the legal basis for the award of attorney's fees, there simply could not have been an award of attorney's fees without a legal basis to provide it, specifically without a law, a statute, or contract, as required by Section 1032. In the case of Elation Systems Incorporated versus Fenn Bridge, LLC, citation 71 Cal App 5th 958, the court expressly stated, and I'm quoting here, as we must decide whether Section 1717's requirements were satisfied here, our review is de novo. Therefore, and as further stated by the case of Douglas E. Barnhart Incorporated versus CMC, Section 1717 governs attorney's fees awards authorized by contract. The referee's order did interpret the language of the contract and awarded attorney's fees. The referee's order did make a finding that CB Cal was the prevailing party.
Let me ask a question there on the referee's finding that on the prevailing party issue. What is the standard of review for that finding?
That standard review involves a legal question, and specifically whether the referee applied Section 1717 B1 or B2. And with that in mind, Section B1 explicitly states that the party prevailing on the contract shall be the party who recovered a greater relief in the action on the contract, except as provided in paragraph 2 or subsection B2. Subsection B2 precludes an award of attorney's fees, or actually expressly, it precludes a finding of a prevailing party when the plaintiff voluntarily dismisses their case on a contract voluntarily. Doesn't matter when they do it, before trial, when. In this case, we have a dismissal before trial ever occurred. Furthermore, the referee's order was premised on CB Cal's motion for attorney's fees, which explicitly stated in the very beginning, in the introduction, it states, the first words in the introduction. In California, under Civil Code Section 1717, plaintiffs like NMA who voluntarily dismiss their claims can insulate themselves from paying opponents' attorney's fees under a contractual attorney's fees provision by asserting only contract claims. That was the first sentence in their introduction for the motion for attorney's fees. That same section is the section that the referee implicitly granted the attorney's fees here. Can't bake a pie without flour. Therefore, because it was a legal determination or a determination on law, we submit that this appeal is governed by the de novo standard of review.
Is there any question as to who is the prevailing party here, regardless of what the standard is?
Yes, Your Honor. So the Santisas case, and thank you for mentioning that, the Santisas case only looks at Section B1 for determining whether or not the party is a prevailing party. Specifically, B1 states that a prevailing party must be the, let me see here. Irregardless, Section B1 requires that the prevailing party be the party that benefits from the action. In this case, we don't really have a party that benefited. What we have is CB who got everything that they're saying that they requested.
So you're still arguing they're entitled to zero attorney's fees? Is that what I'm hearing you say?
Yes, Your Honor.
So below, did you make any argument that they were entitled to $1 of attorney's fees, or was it just flat zero?
We didn't argue that they were entitled to any attorney's fees in our opposition. Actually, explicitly, in the opposition, we submit that none of the claims are based on tort cause of action, and under the analysis provided by case law, by the overruling authority applied here, that all of the causes of actions were premised on a contract.
So in the lower court proceedings and the motion for attorney's fees, did you do anything to challenge the 70% allocation of fees?
Yes, Your Honor, there was explicit language. Actually, it's cited in one of the questions posited. It's cited as the clerk's transcripts, 836, lines 16 through 21. And there we actually explicitly state that CB attempt to characterize 70% of NMA's case as sounding in tort must be disregarded because it is contradictory to the position that they have taken since the inception of this litigation. We actually state in that same paragraph, CB motion should be denied in its entirety for the reasons set forth herein.
So just to, I think, maybe ask what Justice Viramontes just asked in a slightly different way, you didn't ever put forth another percentage. Your percentage was zero.
I do not believe we ever put forth another percentage, Your Honor.
Okay, thank you.
But you did put forward zero?
Yes, Your Honor.
So the trial judge had to pick between 0 and 70?
Well, Your Honor, we submitted in the alternative, either each of the causes of actions are premised on a contract, or in the alternative, we're requesting a reduction from the 70% as determined by the referee. I believe that was in our opposition.
Right,
We did not.
But you didn't name a number other than 0.
No, Your Honor.
And is it your position that the referee or the trial court had a responsibility to come up with some other number besides 0 or 70?
Yes, Your Honor. As explicitly required, or as,
like what?
To do an independent devalue.
No. What's the number that the decision maker below should have come up with?
We submit here at this appeal that each cause of action was premised on contract and that the percentage is 0. A party cannot be...
Oh, so you're back to the 0 or 70 and nothing in between.
There has to be independent analysis done on each cause of action to determine if that cause of action was premised on contract or not. The referee here, both in the evidentiary hearing held on this issue and on the order on this issue, made absolutely no finding of fact of whether any cause of action was premised on contract or otherwise.
So what is the method that the decision maker should have used to pick a number between 0 and 70?
Thank you, Your Honor. There's actually a standard applied, as expressly stated in the case of Douglas E. Barnhart Incorporated.
Wait, could you slow down a little?
Yes, Your Honor.
Say that again.
Douglas E. Barnhart Incorporated versus CMC Fabricators Incorporated.
Is this in your brief?
Yes, Your Honor.
And just give me the rest of the site, please.
That's 211 California App 4th, 230, and pin site of 242.
Thank you.
And that standard that they state for how a court can determine whether a cause of action is premised on contract or not, they expressly state a cause of action is on contract pursuant to Section 1717 if it involves the contract in the sense that it arises out of, is based upon, or relates to an agreement by seeking to define or interpret its terms or to determine or enforce a party's rights or duties under the agreement.
Okay, so that's how to tell if something's based on the contract or not, right?
Yes, Your Honor.
But suppose there's 7 claims in the complaint and 4 are tort and 3 are contract. What percentage, how do you allocate between that split?
You could do one or two things. You can apportion it directly as a pro per or pro rata of you have 3 out of 7 claims. 3 are based on contract. You have this amount of attorney's fees. Okay, you get 4 out of 7. So
you count each cause of action as equal.
That would be one method.
But isn't that crazy?
It is.
Yeah, that's crazy. So let's go to the next one.
I would agree with you. The other method would be made possibly crazier with whether or not an attorney would be required to articulate or demonstrate what efforts he made towards certain cause of action to the other.
So you say that's crazier?
Yes, Your Honor. Okay,
so it sounds like we got 0, 70, and then crazy and crazier.
We're getting there, Your Honor. Okay, so the case of Blickmark Turkis LP versus MF Downtown Sunnyvale LLC, citation 162.
I want to go back to crazier for a second. That's the method where an attorney is supposed to say, okay, I'm going to look at each of the 1,000 hours I've billed in this case and say, okay, hour 1. Was that on the 4 causes of action or the 3 causes of action, or was it a little bit of some and more of the other? That's the crazier method?
Yes, and I would...
So remanding for a trier of fact or the decision maker to do that, you wouldn't like that?
I would appreciate that, Your Honor.
You would?
Yes, because...
You want us to go with the crazier method?
No, Your Honor, not with that method, but a determination does need to be made as to what causes of action were premised on a contract versus what cause of actions were theoretically or allegedly based on tort. And to summarize, to give a much clearer picture of this, Section 1717 is explicit and express. It states that a cause of an action on contract. It doesn't say a claim. It doesn't say a cause of action. It states that any action on a contract. Now, my suggestion would be to determine whether an entire case is on a contract or not. And cases, appellate court decisions have actually come to this determination. Specifically...
So if we agree with the trial court that the bulk of this is not on a contract, then 70% is okay.
The trial court the referee in this, made no determination whatsoever of what causes of action were on contract or not. The case of Kahn requires that such a determination be made.
Well, the referee went with the moving party's suggestion, right? They said 70%. The referee says, yeah, sounds about right.
Yes, Your Honor.
And you're saying the referee should have said more, should have written a term paper about that.
Yes, Your Honor. And I would submit that decision was arbitrary and capricious to the extent that...
But you're also saying that the referee can globally look at everything and decide it's 0 or 100.
Yes,
so you
sure.
don't need to sparse it out claim by claim.
I would say a review of claim by claim would be necessary to determine the complaint or the action as a whole, as to determine whether or not the action in and of itself is on a contract or not.
Action like the entirety of the case instead of claim by claim?
Yes, Your Honor.
Wouldn't that be in conflict with the Sentesis case and other cases that have interpreted Sentesis that have made some type of allocation?
Yes, it would be somewhat in conflict. However, recent decisions have come to this conclusion. Specifically, the case of Blickman Turkis LP versus MF Downtown at Sunnyvale LLC, citation 162 Cal Appellate 4th 858. It states in no uncertain terms, as long as the action involves a contract, it is on the contract within the meaning of Section 1717. And that's a 2008 case. And a more recent decision, Turner v. Schultz, 2018, 175 Cal Appellate 4th 974, states the same thing.
So are you saying these cases are overruling Sentesis or what?
No, Your Honor.
Okay, so what are you saying then?
So the Sentesis case is interesting in the fact that it provides no analysis for determining whether or not an action as a whole or a cause of action individually is premised on a contract.
They actually went through one and said and did an analysis. How can
they've made an analysis that a breach of contract claim was on a contract. They provided no standard for making that decision. They looked at the arguments posited by the respondent there that the fraud, the misrepresentations in that case, in the Sentesis case, the respondent was arguing, actually, my apologies, I believe it was the appellant that was arguing, I'm not certain, that because of the fraud and misrepresentation that took place, that therefore it's a breach, it's a tort cause of action, even though it's an explicit breach of contract cause of action. So they did that small dicta, I would say. It's not really an independent standard that they applied. The Douglas case gives us a standard to apply. Now, this case, I would request that this case is absolutely an action on contract. Specifically, the complaint in its entirety references the contract more than 50 times. First cause of action is for breach of a written agreement. Specifically, it goes into the execution of the agreement.
But the plaintiffs wouldn't have been satisfied with only contract damages, right?
Your Honor, could you...
The plaintiffs would not have been satisfied with mere contract damages, though, right? They want tort damages. They want pain and suffering. They want access to punitive damages. That's the point of pleading torts, right?
There was no pain and suffering requested in the remedies request.
There was punitive damages, weren't there?
Yes. And as we all know, just because you plead a request for punitive damages in your prayer for relief doesn't mean you're going to get it.
Doesn't mean you're going to get it, but it sure changes the settlement value of the case.
It may or may not, depending on...
Yes, it may.
It may.
And didn't your client's damages expert put forth theories of damages that were grounded in tort rather than contract?
Your Honor, the prayer for relief in the complaint...
I'm not talking about the prayer for relief now. I'm actually talking about the damages analysis done by the expert.
I wasn't trial counsel for this case.
But you're familiar with the record.
It is
Yes,
in the
Your Honor.
record.
Yes, I believe that some of the damage analysis did go to punitive damages, yes.
And based on tort causes of action.
No, Your Honor. So
I believe there was damages request for distribution of misinformation, an intent to poach clients. I mean, that doesn't sound like contract damages to me.
So that is in the sense that our cause of action for promissory fraud in the representation...
Promissory fraud.
Promissory fraud, thank you, Your Honor. That the sense that the representations made by CBCal that they would be a loyal acquiring bank for NMA would not seek to obtain the merchants or onboard the merchants of NMA, that goes to the breach of contract. The consequential damages of that breach and so on and so forth. So the cause of action in this case are breach of written agreement, another cause of action for breach of contract for secondary agreement, a breach of the covenant of good faith and fair dealing, and a cause of action for unjust enrichment premised on CBCal withholding funds that they obtained through the parties' performances of the contract and the parties' relationship of the contract, a cause of action for unfair business practices, which relies on the conduct of CBCal through the performance of the parties' contractual relationship, namely that CBCal obtained NMA's proprietary systems, business portfolio, and then it took their business. Again, that's through the performance of CBCal's performance of the underlying contract.
So your position is there's a contract involved here, and that's really all we need to know.
Yes, Your Honor.
But from a damages point of view, it seems as though the tort theories swamped the contract theories.
No,
you might say it was like, what, 70% of the case?
No, Your Honor, I would disagree with that. Specifically, the prayer for relief requested 5 types of remedies. It requested restitution and or disgorgement, compensatory damages, punitive damages, attorney's fees and costs, and then prejudgment interest. I would say that at least, if not all of them, 4 out of 5 of those are strictly premised on contract or just generic requests for relief.
Counsel, you've overused your time. I'm going to ask you to take your seat. We'll let the other side present their case, and I'll give you some rebuttal time.
Thank you, Your Honor.
Thank you.
Good afternoon. Response to the questions. Determination of prevailing party, we agree, is de novo. And we agree that the referee got it right, that under any analysis, when defeated a $200 million claim for damages and won, we were the prevailing party. The determination of the amount and the percentage allocation between contract and tort is messy. It is largely a factual question. And I can't think of any hard and fast rule Your Honors could put into an unpublished or published decision that would apply across all cases. If 3/7 are contract and 4/7 of the stated, if the cover of the book says 3/4 and 3/7 and 4/7, that is how it has to be allocated at the end. I don't think that's reflective of reality. And I think what has to be determined is it has to be a factual issue. Here, the facts were, these claims are inextricably intertwined. Every contract claim. It's one thing we agree about. All the tort claims, they say, was related to the contract. That may be. All of the contracts were infiltrated with tort language. And the reason was that this is a highly unusual unicorn-type situation where you have 3 consecutive contracts entered into between a company represented by counsel that generates tens of millions of dollars in revenues a year, and the bank represented by counsel. The third contract had a written waiver of all of the plaintiff's claims. At the outset, we said, this doesn't happen very often. Let's just ask the referee to determine the validity of the third contract's written waiver of all claims. Have only discovery relate to that. Let's keep this small and limited and have that to single determination. NMA said, oh no, this is a 3-year tortious scheme by the bank. You have to get the referee. We need discovery on all 3+ years. We need discovery of their other similar, payment processing companies to show that they discriminate against us because the leader, Ms. Altapeter, was a woman. And so you invite the court, if any doubts, to read over the First Amendment complaint. It says that each claim is that this was a lengthy scheme started before any of the agreements were signed that targeted NMA to steal its proprietary information and that it involved the entire relationship. It's in paragraph 25. At 29, they said the purposeful breaches of the contract were to put NMA out of business, take control of its proprietary systems. Even when we complied with the contract, NMA alleged that was evidence of a subterfuge to get further access to the proprietary systems. And they said when we were complying with the contract, it was when Ms. Altipeter was out of power, the referee had taken over for a period of time. And so our performance when a male referee was in charge was evidence of our sex discrimination against her. It's tortious when we breached the contract. It's tortious when we comply with the contract. Each of the first two contracts alleged the signing of the contract was alleged to be fraudulent inducement. The signing of the third contract was alleged to be a coercion, which is the equivalent of a fraud. And from attending the hearing in front of the referee, it was clear they wanted to say, yes, it was only through years of ongoing various types of torts that NMA was put into such economic duress and that they were effectively coerced and defrauded into signing the third agreement so that the waiver cannot be effective. So
let me ask you, in
yes.
determining whether something is a contractual allegation or a tortious, when you said it's a finding of fact, why would that be when we're essentially comparing legal allegations? Doesn't that at least have some legal component?
Certainly might. Yes, it could be a mixed question of law and fact, depending upon the allegations and the facts. Yes.
Okay, so if that's the case, it's a mixed question of law and fact. Is there any authority for the proposition that when the Supreme Court says, here's a question of law you have to decide, that the trial court, in this case, a referee, doesn't have to decide it and can just say, 70%?
I believe he did decide it. And I think it's the referee did more than just, granted. The referee, Judge Haberfeld, was the only judge on this case, and he attended numerous hearings. He's familiar with all the facts.
But you're asking us to infer it was decided, because I don't see anywhere in the record it was decided, unless you can point us to where we have a decision on this.
Sure. He said, Judge Haberfeld said he had read all the papers in his decision. Further, it was also said at the hearing. NMA had lots of opportunity to oppose. This was not just a post-dismissal motion that was done on the papers only. There was a live hearing. I testified. NMA called me to testify. Mr. Marshall, the other lead counsel for the bank, was also called and testified. I had already given in my declaration. We have already given in all of our bills. We had given all $1 million+ in fees and costs, itemized except for attorney-client privilege redactions. And they had every opportunity to ask me and Mr. Marshall, what did you do? Why'd you do it? Why'd you think it was tort versus contract? Nothing. No questions. In my mind, I believed still today, you read the First Amendment complaint, the contract breach causes of action, the breaches were alleged to be torts. You breached by fraudulently inducing us. You breached by trying to steal our customers.
So you say the whole thing's really 100%?
Yes, I thought in my mind,
and so
could have asked for 100%.
I think at the time,
Yes.
I think at the time you said we're rounding down, or didn't you say something to the effect that, we're being conservative, is just 70%?
Yes, that's exactly right. In my mind, I thought it would be under the old trial lawyer saw. I thought the entire thing was 100% mixed contract.
Because it's kind of a settlement offer to the referee. We should be asking for the whole thing, Your Honor, but I'm such a nice guy, we'll give him a break today.
Yes, more than that. I think it's when you're a trial lawyer and you think about the case, this case was all about the torts. It was almost nothing about the contracts. As Your Honor pointed out, the damages mentioned nothing about breach of contract. All of the categories of damages were entirely torts. So by their own admission, we think it was all about the torts. Nonetheless, I said, the old trial lawyer saw is to prove that the sun comes up in the east in front of a jury, you only have about an 80% chance of winning in court. So I was going to ask for 80%. I said, we're not going to be greedy. Let's back it off a little bit. We'll ask for 70%.
Okay, so was it you that came up with 70%?
Yes,
So
my declaration.
And how did you come up with 70%?
Like I said, I thought it was 100. I didn't want to be greedy. They say cows graze, pigs get slaughtered. I wanted to respect Civil Code Section 717 in the Santesis case. I did not think that, we are not.
So you're looking for a straight face number?
Yes. This was.
I can say it to the judge. The judge is going to say, I think you're a reasonable person. You're a good lawyer. We'll go with the 70%. And what's the alternative to that? I guess the alternative would be to go hour by hour. What did you do? How many hours, or over 1,000 hours?
I think so. I mean, my hourly rate was $385. So
No. The number of hours, not your rate.
I don't recall it. There was a lot. It was over $1 million. Yes.
Yeah.
So yes, it had to be over 1,000 hours.
So under the mechanism where you got to carve it up, first you got to decide what's a contract, what's a tort. Then you got to go through each hour and figure out whether each hour counts for a contract or tort or both. And then for the stuff that counts for both, you have to fight about that.
Not necessarily. It depends what the standard is. So I was thinking, when you represent an insurance company and there are covered and uncovered claims, the insurance company has to pay for all of the legal work except for that separate legal work that is solely for an uncovered claim. And so here, I looked at the bills. I could not find any work that was strictly allocated for the contract claim. So I thought that was another way I could ask for 100%. But again, we're not an insurance company.
I guess if you're going to demur, and you demurred only to a contract claim, then you could say, okay, that demur was only about the contract claim. But otherwise, it's just it's all in the blender, right? It's just
yes,
it's inextricably intertwined.
It is, and I think when it comes to the insurance company situation, what does an insurance company have to pay for when there are covered and uncovered claims to the insured? I'm quite familiar that insurance company has to pay for everything except for what is clearly, totally allocable to non-covered claims. Here, everything was betwixt and between and intermixed. There's flour everywhere.
Is there any case, any authority you can point us to what to do when it's all mixed up? Intermixed, as you say?
My partner knows the law a little bit better. If it's permissible, Mr. Case could address that.
As long as you are all okay, I'm okay.
Thank you.
Yes, we cited the Ananda case in our papers, which is one of the cases that says when the tort and contract claims are inextricably intertwined, the trial court has no responsibility to make an allocation. There's cases after that as well. But this was one of those cases at the clerk's transcript, page 621, lines 5 through 6. That's where we cited the Ananda Church of Self-Realization versus Massachusetts Bay Insurance Company, 95 Calab 4th, 1273 at page 1281. Issues are determined from the facts alleged rather than from the title of the pleadings. And okay. Erickson versus REM Concepts, Inc., 126 Calab 4th, 1073 at page 1083. Quote, apportionment of a fee award between fees incurred on a contract cause of action and those incurred on other cause of action is within the trial court's discretion.
Can you just please repeat the citation?
Erickson versus REM Concepts, Inc., 126 Calab 4th, 1073 at page 1083.
Thank you.
Clerk's transcript, page 631, lines 27 through 28, and 632, lines 25 through 28. Where the claims are inextricably intertwined with the tort such that apportionment is practically impossible, the court does not need to apportion the claims. That's Reynolds Metals Company versus Alperson, 25 Cal 3rd 124, pages 129 through 130. Quote, attorney's fees need not be apportioned when incurred for representation on an issue common to both the cause of action in which fees are proper and one in which they are not allowed. Also cited in our papers below, Abdallah, Abdallah versus United Savings Bank, 43 Cal App 4th 1101 at page 1111. Trial court need not apportion fees between inextricably intertwined contract and non-contract claims. Also, Siligo, Siligo versus Castellucci, Castellucci, 21 Cal App 4th 873 at 880. No apportionment between fraud and contract claims was necessary where the fraud, quote, constituted part of the cost of enforcing the contracts, end quote. These were all cited in our papers below.
Want to wrap up, counsel?
I would be happy to. If I can just check my notes and see if there's anything else, any other questions. I think there's one last.
Let me ask you, so under that mechanism, then the trial court would go through figuring out what is tort, what is contract, and then if it's so intermixed, then it doesn't really matter what was tort and what was contract?
Correct. It's within the trial court's discretion to make a determination. If it is so intermixed, he can award all the fees. And it would be within his discretion to say he's going to do the deep dive and parse out, saying 90% of the allegations are tort or not. One other point: not only did the referee said he read the papers and listened to the live argument, it was clear there was nothing he considered that was improper. He did what he was supposed to do and was a good judge. There's no other questions. Thank you.
Thank you, counsel. Mr. Daggett, take 2 minutes to wrap up.
Thank you, Your Honors. I would say that the only question that this court has to answer is whether the complaint, the action in its entirety, was on a contract or not. As you heard our respondent just admit, the entire cause of action or the entire action in its entirety was premised on the negotiations, the execution, and the performance of the parties' contracts. Section 1717 states that the question is whether or not the action is on contract. On that premise alone, Section 1717B2, the legislature's purpose for that section is to allow a plaintiff who asserts an action on a contract to voluntarily dismiss their case without fear of being subjected to an award of attorney's fees. I would highly suggest to look at the complaint and read the cause of action and see that I frankly do not find that the allegations in that complaint submit to tort allegations. They are all cause of actions based on contract. The case, the complaint references the contracts more than 50 times. The case of Blickman is dispositive here, which decides that the complaint, which references the agreement of the parties, only 14 times, that entire action is premised on contract. That Blickman case dealt with cause of action for concealment, breach of fiduciary duty, negligence, and negligent supervision. I would submit that all of those cause of actions are facially tortious. However, the complaint referenced the parties' agreement 14 times, and the appellate court found that the action in its entirety was on a contract and prohibited an award of attorney's fees on that basis. Therefore, appellants respectfully request a reversal of the referee's order and remand for a determination of the action in its entirety of whether or not it's on a contract.
Thank you, counsel. Thank you both. This matter will stand submitted.
I'd observe that there was an initial election to appear remotely, and we all support that when it's convenient and in counsel's discretion and the client's judgment. But it was very beneficial to have everybody here in person. Excellent argument. A lot of fun.
Thank you, Your Honors.
And I think thank you both, but it should be thank you to all three of you. Thank you. Number